This is my message sent to Pat King, who was falsely arrested, charged, put on trial, and convicted. The criminal code doesn't apply in your case because no criminal offenses were committed. No federal roadway was blocked, so the federal criminal code does not apply. The criminal code only applies if a federal roadway was blocked under the Government Property Traffic Act. These were only City of Ottawa bylaw offenses. Ottawa's Traffic and Parking Bylaw Number 2017-301. See Sections 103 to 109. Ottawa's Noise Bylaw Number 2017-255. See Sections 3 and 15. The Court of Appeal made a jurisdictional error, not a legal error. The criminal courts have no jurisdiction in your case, and they never had any from day one. The bylaw offenses committed here are to be heard by the Quasi-Criminal Ontario Court of Justice, not the Criminal Superior Court of Justice. Offenses in Canada are classified, and all of the bylaw offenses committed are absolute liability offenses. You are guilty once you commit the offense. All of the trucker protest videos prove the offenses were committed. You are not entitled to field a defense in court. Jurisdictional errors are corrected by certiorari in a higher court, which is the Supreme Court of Canada under Section 55. Ergo, I believe you now need to file for a writ of certiorari in the Supreme Court of Canada, which will end this case once and for all. The government only had 6 months to charge you with the bylaw offenses. That period of time has long passed. You are facing a $20 to $100 fine for illegally parking. If you didn't illegally park a vehicle yourself, but told others to illegally park, then you are facing up to a $5,000 fine. You are facing between a $500 to $1,000 fine for the horn noise violation, and up to $5,000 for counseling others to breach the injunction. Telling someone to breach the injunction was just a quasi-criminal Municipal Act offense, not a criminal offense. Both Municipal Act Section 426 and Provincial Offences Act Section 78 say so. You have not been convicted of anything, because the Superior Court of Justice had no jurisdiction. The court decisions are void. Something void doesn't exist. You cannot appeal something that does not exist. Thus you must file for a writ of certiorari in the Supreme Court of Canada. Real justice. King of the case. And always ahead of the parade.